When I signed the closing papers on my new townhouse in Meadowbrook Estates, I felt a mix of excitement and trepidation. After years of apartment living, I finally had a place to call my own. A charming two-bedroom with a small garden patio in a quiet suburban community. The excitement was natural. The trepidation came from wondering how my new neighbors would react to my situation. 3 years ago, a car accident left me with nerve damage and chronic pain that qualified as an invisible disability. Most days I could function normally, but flare-ups could leave me struggling to walk even short distances. On those days, every extra step felt like walking through fire. My handicap parking permit wasn't a convenience. It was a necessity that allowed me to maintain independence during unpredictable flare-ups. The moving company had done the heavy lifting the day before, and today I was arranging smaller items and making my new house feel like home. My first interactions with neighbors had been promising. The retired couple next door brought over a homemade lasagna, and a young family across the street offered local restaurant recommendations. By late afternoon I was exhausted. A combination of unpacking and the stress of moving had triggered the familiar burn in my legs that warned of an impending flare-up. I decided to drive to the pharmacy to pick up my prescription refill before the pain intensified. My assigned parking space at Meadowbrook was a designated handicap spot near my front door, a key selling point that my real estate agent had negotiated with the HOA before closing. I had provided all the required documentation, and the space was officially reserved with fresh blue paint and signage. As I returned from the pharmacy and pulled into my spot, I noticed a woman watching me intently from her front porch 3 doors down. She appeared to be in her mid-50s, with a precision-cut blonde bob and an expression of concentrated skepticism. Something about her posture, arms crossed, head slightly tilted, triggered a familiar sense of dread. I recognized the look of someone making judgments about my disability status based on my appearance. I gathered my pharmacy bag and carefully exited my car, making sure my handicap placard was properly displayed on the rearview mirror. Before I could reach my front door, the woman was approaching with determined strides. "Excuse me," she called, her voice carrying the artificial sweetness people use when they're about to say something unpleasant. "I'm Diane Mitchell, HOA Board President. Are you just visiting someone?" "No, I just moved in yesterday," I replied, extending my hand. "I'm Alex Jensen, the new owner of 42 Maple Court." She ignored my outstretched hand, her gaze fixed on my car. "I see you're parked in a handicap space. Those are reserved for residents with disabilities." "Yes, I'm aware. This is my assigned space," I explained. "I have a valid handicap permit and all the paperwork was processed before closing." Diane's eyes narrowed as she assessed me from head to toe, a familiar evaluation I'd endured countless times since acquiring my permit. At 35, reasonably fit-looking, and currently walking without assistance, I didn't match many people's mental image of disabled. "You seem perfectly able-bodied to me," she said, the artificial sweetness evaporating. "We take accessible parking very seriously in Meadowbrook. Too many people abuse these privileges." I took a deep breath, fighting the urge to explain my medical history to a complete stranger. "I understand your concern for proper use of accessible parking. I assure you my permit is legitimate and medically necessary." "What exactly is your disability?" she pressed, stepping closer. "The previous accommodation was for Mrs. Levin, who used a wheelchair. You're clearly walking just fine." The familiar heat of embarrassment and frustration crept up my neck. "I'm sorry, but my medical information is private. My doctor and the DMV have verified my need for accessible parking." Diane pulled out her phone and began taking photos of my car, my license plate and my handicap placard. "As HOA president, I have a responsibility to ensure community rules are being followed. I'll need to see documentation proving your disability." "Actually, that's not correct," I replied, keeping my voice calm despite my rising anxiety. "The Americans with Disabilities Act and Fair Housing Regulations protect my medical privacy. The HOA has already received proper notification of my accommodation needs through my closing documents." Her expression hardened. "Perhaps things work differently where you lived before, but at Meadowbrook we have verification protocols. I'll need medical confirmation, or you'll have to park in standard spaces." A door opened nearby, and the retired gentleman who had brought over lasagna emerged. "Everything okay over here, Alex?" he called, clearly sensing the tension. "Just introducing myself to our new neighbor and explaining our parking regulations. I've actually already reviewed the HOA covenants," I said, addressing both of them. "There's nothing requiring residents to disclose private medical information to board members. My accommodation was properly processed through the appropriate channels." Diane's smile tightened. "Well, we'll just have to see about that. Welcome to Meadowbrook, Alex." She turned and walked away, already typing something on her phone. My neighbor approached as Diane retreated. "Don't mind Diane," he said quietly. "She appointed herself parking enforcement years ago. I'm Tom, by the way. Nice to meet you properly, Tom, and thanks for the lasagna." "No problem. Just—" He hesitated, glancing in Diane's direction. "Just be careful. Diane tends to fixate on what she considers rule violations. Your parking spot might become a thing." I nodded, watching as Diane stopped to take additional photos of my car from another angle. "It wouldn't be the first time," I said. "Unfortunately, invisible disabilities tend to invite unwanted scrutiny." Tom patted my shoulder sympathetically. "Most folks here are good people. Diane's just—" "Diane, let me know if you need anything, neighbor." As Tom headed back to his townhouse, I finally entered my new home, the excitement of home ownership now tinged with familiar anxiety. My legs throbbed with pain that had intensified during the confrontation, a cruel reminder of why I needed that parking space in the first place. I placed my medication on the kitchen counter and sank into the nearest chair, massaging my aching legs. Through the window, I could see Diane still lingering near my parking space, now appearing to measure its dimensions with steps. I had faced disability skepticism before, but something about Diane's authoritative demeanor and immediate documentation suggested this wouldn't be a simple misunderstanding easily resolved with education. As I swallowed my medication, I wondered if my peaceful new beginning at Meadowbrook was already compromised. What I didn't know then was that this brief encounter was just the opening skirmish in what would become a full-scale neighborhood war, one centered not around property lines or noise complaints, but around my basic right to exist in my home with the accommodations my disability required. Within a week of moving in, I'd established a comfortable routine at Meadowbrook Estates. Mornings meant coffee on my small patio, evenings were for me exploring nearby walking trails on good days, and my home office was finally set up for my remote graphic design work. The neighborhood seemed peaceful, except for one persistent issue. It started with a note tucked under my windshield wiper. 3 days after my encounter with Diane, "Handicap spaces are for real disabilities, not conveniences. You are being monitored." No signature, but the crisp printer paper and perfectly centered text suggested someone who took their self-appointed enforcement role very seriously. I sighed, photographed the note for documentation, then tossed it in my growing Diane file. 2 days later, another note appeared. "Observed you carrying groceries without difficulty. Miraculous healing or fraud." Tom, my retired neighbor, caught me taking photos of this second note. "Diane again?" he asked, shaking his head when I showed him the message. "She seems particularly invested in my parking situation," I replied. "You're not alone," Tom explained, lowering his voice. "The Rodriguez family left last year after she reported their teenage son for using their handicap spot when he drove his grandmother's car. And Mrs. Levin, who lived in your unit. Diane photographed her whenever she moved from wheelchair to car, claiming she was testing for inconsistencies. This information was troubling. Isn't there someone on the board who can rein her in? Her husband is the board treasurer, and her tennis partner is the vice president," Tom replied. "Most people just try to stay off her radar." That afternoon, I decided to research both my rights and the HOA regulations. The Americans with Disabilities Act and Fair Housing Act were clear. Requests for detailed medical information by HOA board members were inappropriate, and harassment based on disability status was explicitly prohibited. Meadowbrook's own bylaws stated only that appropriate documentation must be on file with management, which mine was. Nowhere did it authorize board members to conduct independent investigations of residents' disability status. Armed with this knowledge, I felt more confident, until I returned from a doctor's appointment to find Diane standing near my parking space with two other women, gesturing animatedly toward my empty spot. "It's just suspicious," I overheard as I approached. "She drives, shops, and walked the community trail yesterday. Meanwhile, legitimate disabled residents struggle to find close parking." I considered avoiding this. Wasn't going away on its own. "Good afternoon, ladies," I greeted them, forcing a pleasant tone. "I couldn't help overhearing your concerns about my handicap permit." The two women looked embarrassed, but Diane squared her shoulders. "We were discussing community accessibility issues. Specifically my accessibility, it seems," I replied. "I'd be happy to explain how invisible disabilities work. Not all disabilities require mobility devices, and many of us have fluctuating symptoms." One woman mumbled something about needing to check dinner and quickly departed. The other lingered, awkwardly before following. "You're creating quite a disruption in our community," Diane said once we were alone. "Several residents have expressed concerns about your use of accessible parking." "By several residents, do you mean yourself?" I asked. Her eyes narrowed. "I've been maintaining community standards here for 12 years. I know when someone is gaming the system." "I understand you believe you're protecting resources for disabled people," I said carefully. "But policing my disability status isn't part of the HOA's authority. My accommodation is legally established." "We'll see about that," she replied, before walking away. That evening, a neighbor I hadn't met stopped by to introduce herself. "I'm Rachel from Unit 36, she said. "I wanted to warn you about Diane. She's escalating." "How so?" "She's circulating a petition about accessible parking abuse and showing people photos of you walking without assistance, carrying groceries, things like that. She's calling you a permit fraudster to anyone who'll listen." I felt a familiar knot of anxiety tightening. "Has she done this before?" "Yes," Rachel confirmed. "I have multiple sclerosis. When I moved in, she demanded medical records because I looked too young to be disabled. Eventually, she moved on to other targets, but it was hellish for months." The next morning revealed yet another note, this one tucked into my mailbox, a federal offense I chose not to point out. "Board meeting, Thursday 7 p.m. Your parking privilege will be reviewed. Bring medical documentation." This crossed a line. The HOA had no authority to review my legally established accommodation, let alone demand medical records at a public meeting. That afternoon, I installed a small security camera with a view of my parking space and front door, a precaution that proved immediately valuable. Just before dusk, my phone alerted me to movement. On the live stream, I watched Diane examining my handicap placard, testing whether my car doors were unlocked, and appearing to photograph my vehicle identification number through the windshield. The following day, flyers appeared throughout the neighborhood. "Community alert, handicap parking fraud awareness meeting, protect resources for the truly disabled." While the flyer didn't name me directly, the timing left little doubt about who was being targeted. The surveillance and public campaign were becoming impossible to ignore. This wasn't just a nosy neighbor, but coordinated harassment. "You should speak to Linda Harrison in Unit 58, Tom advised when I showed him the flyer. "She's a retired civil rights attorney. When Diane tried starting a campaign to remove children's basketball hoops as unsightly structures, Linda shut it down with one strongly worded letter." As I thanked Tom and headed back to my townhouse, I noticed Diane photographing our interaction from her window. The constant surveillance was beginning to affect my health, the stress triggering more frequent pain flares, creating a cruel irony. Her harassment about my disability was actually worsening my disability symptoms. That night, checking my security footage before bed, I discovered something disturbing. During the afternoon while I'd been working, Diane had approached my car again, this time appearing to manipulate my handicap placard, slightly folding one corner before carefully arranging it to look untouched. The realization sent a chill through me. This wasn't just about parking anymore. Diane was actively tampering with my property, potentially setting me up for accusations of improper placard display, a finable offense in our state. as I saved the footage to my growing evidence file. I knew these weren't just annoyances. They were warning signs of a situation rapidly spiraling beyond typical neighbor disputes. What had begun as misguided skepticism was evolving into targeted harassment. Thursday's board meeting was approaching, and it was clear Diane was preparing for a public confrontation. I needed to be equally prepared, not just to defend my right to accessible parking, but to address a pattern of behavior that was becoming increasingly concerning. Thursday evening arrived with ominous storm clouds gathering both literally and figuratively. I'd spent the day preparing for the HOA meeting, organizing documentation of Diane's escalating behavior, along with printouts. The stress had triggered a significant pain flare, and I reluctantly decided to use my cane, a mobility aid I typically reserved for my worst days. The irony wasn't lost on me. After weeks of Diane's surveillance aimed at catching me being not disabled enough, her harassment had exacerbated my symptoms to the point where I now needed visible assistance. I wondered briefly if the cane would silence her accusations or simply provide new fodder for scrutiny. The Meadowbrook Community Center was unusually crowded when I arrived. Typically, according to Tom, HOA meetings drew minimal attendance, just board members and perhaps a few residents with specific concerns. Tonight, nearly 30 people filled the small room, their hushed conversations stopping momentarily as I entered with my cane. Diane sat at the board table up front, surrounded by stacks of papers and a laptop. She tracked my movement with narrowed eyes, her gaze lingering on my cane with visible skepticism. I chose a seat near the front, determined to address her campaign head-on rather than hiding in the back row. The meeting began with standard HOA business, budget updates, landscaping, schedules, a brief discussion about replacing the pool furniture. Throughout these proceedings, Diane kept glancing in my direction, occasionally whispering to the treasurer, her husband, a quiet man who nodded without making eye contact with anyone. Finally, Walter, the board president, reached new business on the agenda. Before he could proceed, Diane quickly interjected, "I've prepared a special presentation on accessible parking compliance," she announced, standing and connecting her laptop to the projector without waiting for acknowledgement. "We have a situation requiring immediate board attention." Walter appeared, uncomfortable but didn't stop her. "Diane has requested 10 minutes for her presentation," he explained to the room, avoiding looking in my direction. The screen illuminated with a PowerPoint titled, "Protecting Accessibility, Combating Permit Fraud." My stomach tightened as I recognized the first slide, a photo of my car in its designated space, with my license plate clearly visible, though thankfully blurred by someone with more sense than Diane. Meadowbrook Estates has always prioritized accommodations for legitimately disabled residents, Diane began, emphasizing legitimately while glancing pointedly at me. Recently, however, we've observed concerning patterns suggesting potential permit fraud. What followed was essentially a surveillance report on my activities, photos of me walking short distances without my cane, carrying grocery bags, retrieving mail. Each mundane activity presented as evidence of fraudulent disability claims. "While we respect medical privacy," Diane continued, clearly not respecting medical privacy, "the board has responsibility to ensure accommodation resources aren't being misappropriated from truly deserving residents." The room remained uncomfortably silent as she clicked through more photos, including one where she'd circled my legs with a red digital marker, adding the caption, "No visible disability." "Therefore, I propose we require additional verification for all handicap parking assignments, including—" "Excuse me," I interrupted, unable to contain myself any longer. "I need to address several legal and ethical issues with this presentation." Diane turned toward me with a tight smile. "Public comments are reserved for the end of board presentations." "This isn't a general comment," I replied, rising slowly with my cane. "This is addressing a targeted harassment campaign against me personally, using my private information without consent." Walter cleared his throat. "Perhaps we should hear from the resident involved." Diane's smile vanished, but she stepped aside, arms crossed defensively. "My name is Alex Jensen," I began, addressing the room rather than just the board. I recently moved to Meadowbrook, where I've been subjected to escalating harassment regarding my legally established disability accommodation. I outlined the unwanted surveillance, the notes left on my car, the tampering with my placard captured on security footage, and the attempts to demand private medical information. As I spoke, I distributed copies of the Fair Housing Act provisions regarding disability harassment. The behavior demonstrated tonight, publicly displaying my vehicle, tracking my movements, and attempting to classify my medical condition based on photographs, potentially violates multiple federal laws protecting disabled individuals from harassment and discrimination. Murmurs spread through the room as residents reviewed the legal information I'd provided. This isn't about protection for disabled residents, I continued. This presentation included no other residents' vehicles or accommodations, just mine. This. Here's targeted harassment of a legally disabled resident by a board member abusing her position. He stood up from the back Rachel, row. My neighbor. I can confirm this pattern. When I moved in 3 years ago, I experienced identical treatment from Diane, including demands for medical records and surveillance of my activities. Another resident, an elderly man I hadn't met, raised his hand. My late wife used a handicap permit for her heart condition. Mrs. Mitchell repeatedly questioned her because she looked fine on good days. Diane's face flushed red. I'm simply ensuring community standards. You're not qualified to evaluate disabilities, interjected a woman near the window. My son has autism and uses a handicap permit for his safety. Would you like to explain? What evidence would satisfy you for invisible conditions like his? The room had shifted palpably. What Diane had clearly expected to be a community reinforcement of her authority had transformed into a public examination of her behavior. Walter, looking increasingly uncomfortable, finally took control of the meeting. I think we need to clarify some HOA policies. First, board members are not authorized to conduct surveillance of residents or demand medical documentation. Second, the assignment of handicap spaces was properly processed through management for the current resident. There is no legitimate basis for additional verification. Diane began gathering her materials, visibly fuming. If this board won't protect our community standards, the board exists to uphold our bylaws and relevant laws, Walter interrupted, showing unexpected backbone. Not to harass residents based on personal suspicions. This matter is closed. As the meeting moved to other business, Diane remained rigidly in her seat, occasionally shooting venomous glances in my direction. Several residents approached me afterward, offering support and sharing their own Diane stories. It was clear her behavior had affected many community members who had previously remained silent. Walking home in the light rain that had begun during the meeting, I felt both vindicated and exhausted. The public confrontation had gone better than expected, but the stress had taken its toll. My legs burned with pain, each step requiring deliberate effort. I was nearly home when I noticed something blocking my parking space. Diane's SUV was parked at an angle that prevented access to my designated spot. Despite numerous open spaces, nearby she had deliberately chosen to obstruct the one space I needed. This wasn't a misunderstanding or overzealous rule enforcement. This was retaliation, plain and simple. The HOA meeting hadn't resolved anything. It had merely escalated our conflict to a new level. As I painfully made my way to the next available space, significantly farther from my door on a night when every step was agony, I realized Diane's campaign was never really about parking rules or community standards. It was about power, control, and her fundamental disbelief in disabilities she couldn't see or understand. The public confrontation at the meeting hadn't ended her crusade. It had only made it personal. The morning after the HOA meeting, I woke to searing pain shooting through my legs. The combination of stress, confrontation, and walking extra distance due to Diane's parking blockade had triggered one of my worst flare-ups in months. I reached for my phone, reluctantly texting my rheumatologist's office to request an urgent appointment. "Can you come in at 11:30, the receptionist texted back. Dr. Patel had a cancellation. I confirmed the appointment with relief. On days like this, medication adjustments made the difference between manageable discomfort and debilitating pain. I slowly made my way through my morning routine, each movement deliberate and careful. By 10:45, I was dressed and ready to leave, with time to spare for my careful, slower pace. When I opened my front door, I immediately spotted the problem. Diane's SUV was still parked at an angle that completely blocked my handicap space, but now her car was joined by another vehicle, a counter red sedan positioned directly behind where my car was parked in the visitor space I'd been forced to use last night. I was completely boxed in. I stood on my porch, leaning heavily on my cane, staring in disbelief at the strategic placement of the vehicles. This wasn't coincidence. This was coordinated. With growing anxiety about missing my appointment, I called Diane's unit. No answer. I tried the HOA emergency line, which went to voicemail. Growing desperate, I called Tom next door. "I noticed that blockade when I took out my trash this morning," Tom said after hearing my situation. "The red car belongs to Diane's sister. She visits every few weeks, but I've never seen her park like that before. I have a doctor's appointment I can't miss," I explained, "and I can't reach Diane to move her vehicle. I've seen her watching from her window all morning," Tom replied grimly. "She's home, just not answering." With time ticking away and my pain increasing from Stanley's line, the dispatcher assured me an officer would come to address the illegal parking situation, but couldn't provide an exact arrival time. I settled painfully onto my porch chair to wait, watching Diane's townhouse for movement. Occasionally I caught a glimpse of her peeking through her blinds before quickly disappearing from view. She was home, aware of the situation, and deliberately ignoring it. By 11:10, no officer had arrived, and panic began to set in. My medication schedule was precisely timed. Disruptions often meant days of increased symptoms and recovery. With trembling hands, I texted Dr. Patel's office, explaining I was blocked in and might be late. "We'll try to accommodate you, but Dr. Patel has back-to-back appointments after 12:15, came the response. At 11:20, I made a difficult decision. I called a rideshare, despite the additional cost I couldn't really afford, and began the painful process of walking to the complex entrance to meet my driver. Each step sent lightning bolts of pain through my legs, but I focused on the relief the doctor's appointment would eventually provide. I was halfway to the entrance when intense dizziness washed over me, another symptom of my condition when pain levels peaked. I leaned against a tree, breathing deeply, waiting for the spinning sensation to subside. That's when I heard the sirens, not just any sirens, the distinctive wail of multiple emergency vehicles approaching at high speed. Within moments, 2 police cruisers and an ambulance screeched into the complex entrance, lights flashing. To my confusion, they headed directly toward my area of the community. Officer Rodriguez, a policeman I recognized from community outreach events, quickly approached me. "Are you Alex Jensen?" he asked with urgency. "Yes," I confirmed, bewildered by the emergency response. I called about the parking situation, but only requested a non-emergency officer. We received a 911 call reporting a medical emergency at this address, he explained, gesturing for the paramedics. The caller reported a disabled resident in severe distress, potentially experiencing a life-threatening episode. "What?" "I never called 911, I said, confusion giving way to realization, as I turned toward Diane's townhouse. There she stood on her porch, phone visibly in hand, filming the entire scene. The paramedics approached with equipment. "We were told someone with a mobility disability was having a medical emergency," one explained. "Is that you?" "I have a disability, but I didn't call for emergency services," I clarified, embarrassment heating my face as neighbors emerged from their homes to watch the commotion. I called non-emergency police because someone blocked my car, preventing me from reaching a doctor's appointment. Officer Rodriguez's expression shifted from concern to comprehension as he followed my gaze to Diane, who continued filming without shame. "Ma'am, did you call 911? He called to her directly. "I was concerned," Diane replied, her voice carrying for the benefit of her recording. A disabled resident was stumbling and appeared in distress. I acted as any concerned citizen would. The paramedics, now understanding the situation, still insisted on checking my vitals given my obvious pain and the dizziness episode they'd witnessed upon arrival. "Your blood pressure is concerning," the paramedic noted after her assessment. "Are you due for medication?" "Yes," I admitted. I was heading to my doctor because I'm having a severe flare-up, but my car is blocked in. I gestured toward the deliberately positioned vehicles. Officer Rodriguez radioed his partner, who was already examining the parking situation. Those vehicles are illegally parked, his partner confirmed through the radio. One is registered to Diane Mitchell at Unit 36, the other to Elizabeth Mitchell at an out-of-state address. While the paramedics continued monitoring me, Officer Rodriguez approached Diane, who was still recording. "Ma'am, I need you to move your vehicle immediately. You're illegally blocking a designated handicap space." "I was just about to move it," Diane claimed, though she made no movement toward her car. "I was waiting for emergency services to assist with the medical situation I reported." "Ma'am, please put down the phone and move your vehicle now," Officer Rodriguez instructed more firmly. "I'm documenting for safety purposes," Diane insisted. "This resident claims to need special parking, but is clearly ambulatory. I've observed—" "Ma'am," Officer Rodriguez interrupted. "Misuse of emergency services is a serious offense, so is intentionally blocking accessible parking. Please move your vehicle immediately and stop recording." Reluctantly, Diane lowered her phone and walked toward her SUV, still calling back. "I was just being a concerned neighbor. Anyone would have called for help seeing someone in distress." As this unfolded, the paramedics recommended I let them transport me and pain levels. "Can you take me to Lakeside Medical Center instead?" I asked. "My rheumatologist is expecting me, and she has my complete history." They agreed, helping me into the ambulance as neighbors watched. The humiliation of being loaded into an emergency vehicle for what should have been a routine doctor's visit burned almost as much as the pain in my legs. As the ambulance prepared to depart, I noticed Rachel confronting Diane, who was finally moving her SUV. "We all saw what you did," Rachel's voice carried clearly. "You blocked her car deliberately and then called 911 to humiliate her." "I was concerned for a disabled neighbor," Diane insisted, her performance continuing despite lowered phone. "You caused this medical situation," Rachel shot back. "She's having an episode because you prevented her from getting to her doctor and taking her medication." Officer Rodriguez approached the ambulance before we departed. "We'll complete a report about the parking violation," he assured me. "But I also want to document the potential misuse of emergency services. This appears to be a deliberate attempt to create a distressing situation." Through the ambulance window, I watched Diane speaking animatedly to the second officer, gesturing toward me with exaggerated concern. Even now, she was trying to control the narrative, to present herself as the community guardian rather than the cause of this entire situation. As the ambulance pulled away, I caught a final glimpse of the gathering crowd of neighbors, some looking confused, others angry, and Tom standing with arms crossed, shaking his head in disgust at the scene Diane had orchestrated. What should have been a private medical appointment had been transformed into a neighborhood spectacle. Diane hadn't just escalated our conflict. She had weaponized emergency services to further her campaign against me, ultimately causing the very medical distress she claimed to be reporting. As the paramedics radioed ahead to Dr. Patel's office, I closed my eyes against tears of pain and humiliation. This had moved beyond HOA politics or parking disputes into something far more dangerous, and it was clear that Diane had no intention of backing down, regardless of the consequences to my health or the community resources she'd just wasted. News of the 911 incident spread through Meadowbrook Estates like wildfire. By evening, various versions of the story circulated, with neighbors taking sides based on their own relationships with Diane and their understanding of invisible disabilities. 3 days after the incident, an emergency community meeting notice appeared on every door, not Diane's usual unofficial flyers, but formal HOA letterhead signed by Walter and the entire board. The message was diplomatically worded but clear: to address recent events involving emergency services and accessibility accommodations. The community center was standing room only that Thursday evening. I arrived early, still recovering from the medical episode that had required adjustment to my pain management protocol. Dr. Patel had documented the impact of the delayed medication and added stress to my file, both for my treatment plan and, at my request, for potential legal proceedings. Neighbors greeted me with mixed reactions. Many offered supportive words or outraged commentary about Diane's behavior, while others watched with guarded expressions, clearly reserving judgment. A small cluster of residents, mostly Diane's friends from her tennis group and garden committee, huddled near the front, occasionally glancing in my direction with poorly concealed suspicion. Walter called the meeting to order promptly at 7 p.m. For once, he appeared genuinely authoritative, rather than his usual conflict-avoidant self. "Recent events have raised serious concerns about how we function as a community," he began. "The board has received multiple complaints about harassment, privacy violations, and misuse of emergency services. These are not merely HOA matters, but potentially legal issues affecting all residents." Diane sat in the front row, ramrod straight, a binder of papers on her lap. Her husband beside her stared at the floor, visibly uncomfortable with the public scrutiny. Walter outlined the incidents without naming me directly, though everyone knew who was involved. He emphasized that handicap accommodations were legally protected, and community members had no authority to verify or question the legitimacy of disability status. Furthermore, Walter continued, using emergency services to make a point or harass a neighbor is dangerous, costly, and potentially criminal. First responders are for genuine emergencies, not HOA disputes. When discussion opened, Diane immediately stood, dramatically hoisting her binder. "I have documentation proving a pattern of accessibility fraud occurring in our community," she announced, as someone deeply committed to protecting truly disabled Rachel from the second row. "Because you spent 6 months harassing me about my MS until the board finally intervened." "Or my son with autism," added another resident. "You reported us to the DMV claiming we were abusing our handicap placard." Diane remained unfazed. "I'm simply ensuring resources go to the genuinely disabled. I've documented numerous instances of the resident in question functioning without mobility assistance, engaging in activities inconsistent with severe disability." She turned and pointed directly at me. The video evidence speaks for itself. On cue, her friend Marjorie connected a laptop to the projector. Before anyone could intervene, the screen displayed edited footage from Diane's phone, showing me walking short distances, carrying lightweight shopping bags, and bending to pick up mail. "This doesn't look like someone who needs special accommodation," Diane declared triumphantly. Walter moved to shut down the unauthorized presentation, but I raised my hand to speak first. "May I address this directly?" I asked. Walter nodded, looking relieved. I slowly approached the front, aware of all eyes following my progress. "What you're watching is a textbook example of disability harassment through surveillance. Diane has been filming me without consent for weeks, capturing brief moments between pain episodes." I turned to face the room rather than just Diane. "Invisible disabilities like mine are characterized by fluctuating symptoms. Some hours I can walk unassisted. Other times, like after Diane deliberately blocked my car and caused me to miss medication, I require emergency medical intervention." And he, older gentleman in a VA cap, spoke up from the back. "I lost my leg in Vietnam, but sometimes I don't wear my prosthetic. Is someone going to film me on good days to prove I'm not disabled on bad ones?" Murmurs of support spread through the room. But Diane wasn't finished. She distributed printed packets to nearby residents, pages of my activities with dates, times, and her personal disability inconsistency ratings. "This isn't about understanding disabilities," I pointed out, as people flipped through the disturbing surveillance logs. "This is targeted harassment. Diane has specifically focused on me while ignoring other residents with handicap permits." Walter finally took control, stopping Diane's presentation. "The board has consulted our attorney about this situation. Monitoring, photographing, and documenting a resident's activities based on their disability status potentially violates federal housing discrimination laws. This must stop immediately." The meeting fractured into heated exchanges between Diane's supporters and those backing the board's position. Lines were drawn not just around my specific situation, but deeper community values: privacy versus surveillance, compassion versus suspicion, inclusion versus gatekeeping. As the debate intensified, my phone buzzed with an email notification from an unfamiliar address. The subject line made my stomach drop. "Fraudulent handicap claim public notice. I discreetly checked the message to find a mass email apparently sent to everyone in the community email directory. It contained edited clips from Diane's surveillance, footage with damning captions, special parking for someone who clearly doesn't need it, and taking resources from truly disabled people. Most disturbingly, the email included my full name, medical condition, and the inflammatory claim that I was known to authorities for disability benefit fraud. A complete fabrication that nonetheless could damage my reputation and career if believed. As the meeting continued around me, I quietly showed the email to Rachel beside me. Her eyes widened in shock. "This is defamation," she whispered. Pure and simple. I forwarded the email to my lawyer before returning my attention to the ongoing debate. The community had clearly divided. A small but vocal minority supporting Diane's enforcement activities, with the majority uncomfortable with her tactics. Regardless of their personal opinions about invisible disabilities, Walter eventually called for order, announcing the board's decisions, a formal warning issued to Diane for harassment, a clarification of accommodation policies distributed to all residents, and most significantly, Diane's removal from all committees pending review of her actions. "This is outrageous." Diane stood, face flushed with anger. "I've dedicated years to this community while the board has been asleep at the wheel. You'll be hearing from my attorney." As the meeting adjourned in disarray, I remained seated, processing everything. The community division was now complete and public. What had begun as one woman's misguided suspicion had transformed into open conflict, engaging the entire neighborhood. Walking to my car afterward, I noticed something that turned my blood cold. Scratched crudely into my driver's side door was a single word: vandalism of my property marked a dangerous new phase in Diane's campaign. The community might be divided on understanding invisible disabilities, but the escalation to property damage suggested something beyond mere skepticism or misguided advocacy. Neighbors gathered around my damaged car, expressions of shock and sympathy mingling with whispered speculation. The true cost of this conflict became clear. This wasn't just about my right to park in an accessible space anymore. It was about whether I could safely live in my own home at all. The police officer photographed the faker scratched into my car door from multiple angles, his expression grim as he documented the vandalism. This was the third officer I'd dealt with in 2 weeks, first for the blocked car incident, then for the 911 misuse, and now for property damage. "We can't prove who did this without witnesses or camera footage," Officer Reynolds explained. "But given the ongoing situation, we'll add it to the case file." "This pattern of escalation is concerning." I nodded, too exhausted to feel the appropriate level of outrage. "My security camera doesn't have a clear view of this side of the vehicle. I'm guessing whoever did this knew that." "Have you considered additional cameras?" he asked, completing his report. "I'm installing a comprehensive system tomorrow," I confirmed. "My lawyer recommended maximum coverage." After the officer left, Tom approached from his porch where he'd been watching the police response. "This has gone far enough," he said, anger evident in his usually calm voice. "Half the neighborhood saw Diane circling your car after the meeting. She's not even trying to hide her behavior anymore." "Thanks for your support," I replied. "I'm meeting with my attorney tomorrow to discuss legal options." That meeting proved enlightening. Elizabeth Chen of Disability Rights Legal Center listened carefully to my chronology of events, occasionally pausing to ask clarifying questions. When I finished my account, she leaned back in her chair with a troubled expression. "What you're describing isn't just HOA overreach. It's a textbook case of disability harassment under the Fair Housing Act," she explained. "The surveillance, the interference with your accommodation, the escalation to emergency services misuse, and now vandalism. It shows a clear pattern of discriminatory harassment." "What are my options?" I asked. "Multiple avenues," she replied, tapping her pen thoughtfully. "First, we file for a restraining order based on the documented harassment and vandalism. Second, we prepare a formal housing discrimination complaint with HUD, which has specific protections for disability harassment in housing contexts. Third, we send a cease and desist letter to both Diane and the HOA board as her enabling body." She paused, studying my tired face. "This won't be quick or easy. Housing discrimination cases often become contentious. Are you prepared for that?" I thought about returning to my vandalized car in my blocked parking space under constant surveillance. I don't see much choice. This isn't going to stop on its own. Over the next week, I immersed myself in legal preparation with Elizabeth's guidance. We compiled a comprehensive timeline with supporting evidence, photographs of blocked parking, security footage of Diane's surveillance activities, the defamatory email, police reports, medical documentation of my disability, and witness statements from supportive neighbors. Rachel proved particularly helpful, providing detailed accounts of Diane's previous harassment of disabled residents. She typically continues until the person either moves away or gets legal representation, Rachel explained. Most people just leave. It's easier than fighting. Our research uncovered something unexpected. This wasn't Diane's first legal entanglement over disability harassment. A search of county records revealed a settled lawsuit from 5 years earlier, when she had served on the board of a different HOA. The case details were sealed, but the existence of prior legal action strengthened our current case significantly. Elizabeth filed our restraining order request, and a court date was set for the following month. Meanwhile, the cease and desist letters were delivered by certified mail to both Diane and the HOA board, explicitly outlining the legal violations and potential consequences. The board's response was swift, a formal letter dissociating themselves from Diane's actions and confirming their commitment to accommodation compliance. Diane's response, however, was a counterattack. 3 days after receiving our legal notice, I discovered a small black device magnetically attached under my rear bumper while washing my car, a GPS tracker, still actively transmitting. The police were called immediately, their report documenting the illegal tracking device now added to our growing case file. This significantly strengthens our restraining order petition. Placing a tracker on your vehicle shows intent to monitor your movements and could be considered stalking. The same day the tracker was discovered, notices appeared throughout the community announcing a special session to discuss accommodation. Policy updates led by ADA compliance specialist Diane Mitchell. The flyers included official-looking Justice Department logos and accessibility symbols, creating the impression of government-sanctioned authority. She's not an ADA specialist, Elizabeth confirmed after a quick verification check. Impersonating a federal compliance officer could constitute fraud. We need to notify the authorities. Our legal strategy expanded to include documentation of potential federal impersonation charges. Elizabeth contacted the U.S. Attorney's Office with our evidence, adding another layer of scrutiny to Diane's activities. Meanwhile, I'd connected with the Invisible Disabilities Association, which offered resources and advice for handling discrimination cases. Through their network, I found several other disabled residents in neighboring communities who had encountered similar harassment from self-appointed parking police. It's unfortunately common, explained Dr. Morales, the association's legal counsel during our video consultation. People with invisible disabilities often face a double burden, managing their condition while constantly proving their disability to skeptics. The surveillance and public questioning you're experiencing are forms of discrimination that many members report. With Dr. Morales' assistance, we organized a community education session about invisible disabilities. The event was scheduled at the local library rather than the community center to provide neutral territory. Invitations went to all Meadowbrook residents, offering a chance to learn about non-apparent disabilities from medical and legal experts. The response was encouraging. Over 30 residents registered, including several who had previously seemed unsure about whose side they supported. Diane predictably declined the invitation, with a curt note about her extensive existing expertise in disability compliance. While building our legal case, I also focused on practical security measures. A professional security company installed comprehensive camera coverage around my townhouse and vehicle. Their technician, alarmed by my situation, added extra motion-activated lighting as a courtesy. I've done installations for stalking cases before, he explained while positioning the final camera. The lighting sometimes discourages nighttime vandalism. By the end of the month, our legal groundwork was firmly established. The restraining order hearing was scheduled, the HUD discrimination complaint filed, cease and desist notices delivered, and federal authorities notified about the ADA impersonation concerns. We had transformed from reactive victims of harassment to proactive advocates with legal momentum. The morning of our community education event, something unexpected happened. A moving truck appeared outside Diane's townhouse, not for a complete move, but delivering what appeared to be storage containers. Was she preparing contingency plans in case the legal proceedings went against her? That same afternoon, I received an email from a name I didn't recognize, Lawrence Phillips. The subject line read, "Information about Diane Mitchell, willing to testify." The message revealed that Phillips had been the HOA president at Diane's previous community, the one involved in the sealed lawsuit. He had documentation of her pattern of harassing disabled residents there, including board meeting minutes and complaint records predating the lawsuit. "I regret not taking stronger action sooner," his email concluded. Her behavior followed a similar pattern: surveillance, questioning legitimate accommodations, and escalating confrontations. "I'm willing to provide testimony about the previous case if it helps prevent someone else from experiencing what our residents endured." I forwarded Philip's email to Elizabeth immediately. Her response came within minutes. "This is extremely significant. Prior pattern evidence could be decisive in court. Let's arrange a deposition ASAP." That evening, as I reviewed our growing legal file, I felt a strange mix of exhaustion and vindication. The resources required to fight this battle were substantial: time, money, emotional energy. But the alternative was surrendering my right to exist peacefully in my own home while managing my disability. My phone chimed with a text from Rachel. "Just saw Diane removing her ADA specialist flyers after getting a visit from someone in a government vehicle. Your legal strategy is working." Perhaps for the first time since moving to Meadowbrook, I allowed myself a cautious sense of optimism. The legal groundwork we had laid was solid, methodical, and backed by substantial evidence. Diane's campaign of harassment, legitimate enforcement, but as discriminatory behavior with serious legal consequences. The confrontation was far from over, but the balance had shifted. What began as one woman's crusade against my parking accommodation had evolved into a documented case of disability discrimination that could potentially create precedent, protecting other disabled residents from similar harassment. As I closed my legal binder for the night, I noticed something through my window. Residents gathered near the community bulletin board, reading a newly posted notice. Even from a distance, I recognized the blue and white letterhead of the Department of Justice's ADA division. The legal groundwork wasn't just building a case, it was already changing the community landscape. The county courthouse was imposing, all marble columns and intimidating formality. I arrived an hour early for the restraining order hearing, using the extra time to review our evidence one last time with Elizabeth. We sat on a wooden bench in the hallway, spreading documents between us in careful order. "Remember, restraining order hearings are relatively brief," Elizabeth explained. "The judge will want facts, not emotions. Stick to the documented incidents and their impact on your health and safety." I nodded, trying to calm my racing heart. Despite our solid preparation, facing Diane in a legal setting was daunting. For weeks she had positioned herself as the authority figure passing judgment on my disability. Today, those roles would be reversed. Did her lawyer file any response to our petition? I asked. Elizabeth shook her head. That's the strange part. We have no record of her retaining counsel, despite her threats about legal action at the HOA meeting. She may be representing herself. That possibility was both reassuring and concerning. A self-represented Diane might make procedural mistakes, but her unpredictability made her dangerous. At precisely 9:30, the courtroom doors opened. We gathered our materials and entered, taking seats at the plaintiff's table. Minutes later, Diane arrived, alone as Elizabeth had predicted, but carrying a leather portfolio nearly bursting with papers. Judge Harriet Wilson entered promptly, a no-nonsense woman in her 60s with shrewd eyes that missed nothing. After preliminary introductions, she addressed us directly. "This is a hearing for a restraining order based on allegations of harassment and stalking," she began, reviewing our petition. "Ms. Chen, please present your case concisely." Elizabeth methodically outlined the escalating pattern of harassment, from Initial parking disputes to surveillance, property damage, defamation, and the GPS tracker. She presented our evidence chronologically, emphasizing the impact on my health and safety. Your Honor, my client has documented over 30 distinct incidents of targeted harassment based on disability status, Elizabeth concluded. This pattern demonstrates clear intent to intimidate, interfere with reasonable accommodation, and ultimately force my client from her home through persistent hostility. The judge turned to Diane. Ms. Mitchell, your response? Diane rose with rehearsed dignity. Your Honor, I am being persecuted for simply upholding community standards. As an advocate for truly disabled residents, I have observed numerous inconsistencies in the plaintiff's behavior that suggest accommodation fraud. She opened her portfolio, extracting a stack of photographs. I submit these as evidence of the plaintiff engaging in activities inconsistent with severe disability. The judge examined the photos, the same surveillance images Diane had displayed at the HOA meeting. Ms. Mitchell, are you qualified to make medical determinations about disability levels? I have extensive experience. That wasn't my question, Judge Wilson interrupted. Do you have medical credentials or training that qualifies you to evaluate disability status? Diane hesitated. No, Your Honor, and were these photographs taken with the plaintiff's knowledge or permission? I was documenting suspicious activity in public areas, Diane insisted. The judge set the photos aside. Ms. Mitchell, these images demonstrate precisely the surveillance behavior alleged in the restraining order petition. You're essentially confirming the plaintiff's claims. Diane appeared momentarily flustered before rallying. Your Honor, as HOA Compliance Committee Chair, I have responsibility to ensure accommodations aren't being abused. I was performing my community duty. Were you asked by the HOA board to investigate this resident? The judge asked. Not specifically, but please answer yes or no. Diane's jaw tightened. No. And are you currently a member of the HOA Compliance Committee? I've been temporarily removed pending... Yes or no, Ms. Mitchell? No, Diane admitted, her composure cracking slightly. The judge reviewed our documentation. Again. Ms. Mitchell, can you explain why you placed a GPS? For the first time, Diane appeared genuinely shocked. That's a complete fabrication. Elizabeth calmly submitted the police report documenting the tracker, along with its serial number and purchase records tracing back to Diane's credit card. The evidence had been a late addition to our case, one we hadn't disclosed in advance filing. Color drained from Diane's face as she realized the trap she'd walked into. Her denial now contradicted physical evidence, undermining her credibility on all other points. The judge continued methodically through our evidence. The 911 call recording where Diane claimed medical emergency while preventing me from reaching. My doctor, the defamatory community email sent from her IP address. Witness statements about her blocking my car. And finally, photographic evidence of the property damage. Your Honor, Diane attempted one last defense. The plaintiff is taking valuable resources from truly disabled people who genuinely need Ms. Mitchell, the judge interrupted firmly. The law does not appoint private citizens as disability. Police. The plaintiff has legally established accommodation rights that you have repeatedly and systematically interfered with. After considering all evidence, Judge Wilson rendered her decision without hesitation. The court finds clear and convincing evidence of harassment, stalking, and interference with legally protected accommodations. A restraining order is granted for a period of 1 year. The terms were comprehensive. Diane was prohibited from approaching within 100 feet of me, my home, or my vehicle, banned from photographing or monitoring my activities, forbidden from distributing information about me, and explicitly barred from interfering with my parking accommodation in any way. Violation of this order is a criminal offense, Judge Wilson emphasized, looking directly at Diane. The court takes such violations extremely seriously. As we gathered our materials to leave, I noticed Diane sitting motionless, staring at the restraining order with an expression of disbelief. For perhaps the first time, she was facing concrete consequences for behavior she had justified as righteous enforcement. Outside the courthouse, Elizabeth squeezed my shoulder supportively. This is just the first step. The HUD discrimination. Complaint is still proceeding, and we're awaiting the U.S. Attorney's decision about the ADA impersonation matter. I nodded, feeling a complex mix of relief and exhaustion. Do you think this will actually stop her? Elizabeth's expression turned serious. The restraining order has legal teeth, but it's just paper unless enforced. Document any violations immediately. As we descended the courthouse steps, I spotted Rachel waiting beside her car. She waved excitedly when she saw my expression. Good. News? Restraining order granted, I confirmed. 1-year duration with comprehensive restrictions. The community needs to know, Rachel replied, her phone already in hand to spread the word. People have been afraid to take sides without official validation. Driving home, I felt a weight lifted, not completely removed, but lightened. For the first time since moving to Meadowbrook, I could park in my designated space without constant fear of confrontation or surveillance. Yet, as I turned into the complex, I spotted Diane's car already there, parked directly at the entrance, just far enough from my townhouse to comply with the 100-foot restriction while still maintaining visibility of the area. She sat behind the wheel, watching residents come and go, her expression unreadable behind sunglasses. The restraining order had been granted, but Diane's presence at the complex perimeter sent a clear message. The legal battle might be just beginning. Fitzhugh. Restraining order brought an uncomfortable calm to Meadowbrook Estates. Not peace, but a tense ceasefire. For 1 week, Diane maintained technical compliance with the 100-foot restriction, while finding creative ways to maintain her campaign. She parked at the complex entrance daily, watching residents from a legally permissible distance. She recruited allies to distribute flyers about accommodation fraud awareness that never mentioned me by name, but described my situation with unmistakable specificity. Then came the first direct violation. I returned from physical therapy to find an official-looking envelope taped to my door. Inside was a document with Department of Justice letterhead, stating my handicap accommodation was under federal review and requesting I submit medical records to ADA Compliance Officer D. Mitchell within 72 hours. I photographed the document, without touching it further, and called both Elizabeth and the police. Officer Reynolds arrived quickly, carefully collecting the notice as evidence. This violates both the restraining order and potentially constitutes federal impersonation, he confirmed, placing the document in an evidence bag. When the police visited Diane's townhouse, she initially denied involvement, claiming she'd been at her sister's all day. This alibi collapsed when security footage from the community entrance showed her car arriving. An hour before the notice appeared on my door, the violation triggered an immediate response from the court. Judge Wilson scheduled an emergency hearing for the following morning, where Diane received her first taste of serious consequences, a $5,000 fine for violating the restraining order, with a stern warning that further violations could result in jail time. The court does not issue restraining orders as suggestions, Judge Wilson stated firmly. Your deliberate violation shows contempt for this court's authority. This judicial reprimand seemed to finally penetrate Diane's sense of righteous immunity. For the next 2 weeks, she maintained strict distance, though her allies continued distributing materials, questioning the legitimacy of invisible disabilities. During this relative quiet, our legal team pursued another angle. With the help of the Invisible Disabilities Association, we investigated Diane's claims of being an ADA compliance specialist. This inquiry revealed something shocking. She had been presenting herself as an official compliance officer to multiple communities and businesses, conducting unauthorized accessibility audits and even charging consultation fees. This goes beyond harassment into potential fraud, Elizabeth explained during our update meeting. She's been monetizing this fictional expertise. We compiled this evidence and submitted it to the U.S. Attorney's Office, which had already been reviewing our impersonation complaint. 3 days later, 2 federal agents visited Meadowbrook to interview residents about Diane's activities. Their unmarked government vehicle parked outside her townhouse created an immediate stir throughout the community. Meanwhile, I worked with local disability advocates to organize an educational forum about invisible disabilities. We secured the community center for an evening presentation featuring medical professionals, disability rights experts, and individuals with various non-apparent conditions sharing their experiences. The turnout exceeded expectations. Nearly 40 residents attended, including several who had previously supported Diane's enforcement efforts. Dr. Morales from the Invisible Disabilities Association delivered a compelling presentation about conditions like mine, explaining how symptoms can fluctuate dramatically without any visible cues. The most damaging misconception, she explained, is the belief that if someone can walk, carry groceries, or function normally sometimes, they must be able to do so all the time. This fundamental misunderstanding leads to the harmful policing of disabled people's activities. The presentation resonated with many attendees, particularly when participants with invisible disabilities shared their own experiences of being questioned, surveilled, or accused of faking. One elderly resident who had remained neutral throughout the conflict approached me afterward. "I never understood why someone who could walk sometimes would need special parking," he admitted. "Tonight helped me see there's much more to disability than what's visible. I'm sorry I didn't speak up sooner." This educational counteroffensive began shifting community sentiment more definitively in my favor. Even some of Diane's former supporters approached me privately, expressing concern about her methods if not her underlying suspicions. The most significant development came unexpectedly. The HOA board, previously reactive and conflict avoidant, finally took decisive action after consulting with their insurance provider about liability exposure. They called an emergency session and voted unanimously to remove Diane from all committees permanently, revoke her access to community records and communication systems, and implement mandatory disability rights training for all board members and committee chairs. The potential liability her actions have created for the association is unacceptable, Walter explained when announcing their decision. "Our insurance carrier has made it clear, either we address this situation comprehensively or face potential non-renewal of our policy." This loss of institutional power triggered Diane's most desperate counterattack. The morning after the board's decision, residents awoke to find cars throughout the community plastered with printouts of my private medical information, details she could only have obtained by improperly accessing HOA records during her time as committee chair. This violation wasn't just of the restraining order, but of federal health privacy laws. The response was swift and severe. Judge Wilson issued a bench warrant for Diane's arrest on multiple violations, and she spent 24 hours in county jail before posting ankle monitoring and a broader restraining order extending to the entire complex except her own unit. The final blow to Diane's campaign came from an unexpected quarter. Following our complaint, the Department of Justice sent an actual ADA compliance officer to Meadowbrook. This legitimate inspector found multiple accessibility violations in common areas, issues Diane had overlooked during her self-appointed enforcement activities, despite their obvious impact on disabled residents. "The irony is almost perfect," Rachel commented as we reviewed the official compliance report. "She was so busy policing your invisible disability that she missed actual accessibility violations within her authority to address." The report required the HOA to implement specific accessibility improvements within 6 months, ironically, creating more designated handicap parking throughout the community, including visitors' spaces near amenities. As these events unfolded, I noticed a telling sign of community shift. Residents who had previously avoided me now offered supportive words or small gestures of alliance. The counterattack hadn't just been legal, but educational and community building, creating a foundation for understanding that would outlast any single conflict. Diane's campaign of harassment had inadvertently accomplished something valuable, bringing invisible disabilities into community consciousness and ultimately creating a more accessible environment for everyone at Meadowbrook Estates. The morning of the final hearing arrived with an unusual stillness across Meadowbrook Estates. After months of escalating conflict, surveillance, legal maneuvers, and community division, today would bring resolution one way or another. The courthouse was more crowded than before. Not only were Elizabeth and I present, but also several Meadowbrook residents who had been subpoenaed as witnesses, Lawrence Phillips from Diane's previous community, representatives from the Invisible Disabilities Association, and even a journalist from the local paper who had been following the case. Diane arrived with an attorney this time, not the high-powered litigator she had threatened, but a harried-looking public defender assigned after her restraining order violations. Her typically immaculate appearance had slipped. Her signature precise bob was growing out unevenly, and her clothing showed signs of hasty selection. The electronic monitor on her ankle was visible beneath her pant leg. Judge Wilson entered the courtroom, and the proceedings began with a review of all charges and complaints. The original harassment, restraining order violations, impersonation of federal officials, privacy law violations, and potential fraud charges related to her ADA specialist claims. What had started as a simple dispute over a parking space had evolved into a serious legal case with multiple charges across civil and criminal domains. Before we begin formal proceedings, Judge Wilson announced, I understand the parties have been discussing a potential settlement agreement. Is that correct? Elizabeth stood. Yes, Your Honor, we've prepared comprehensive terms that address both remediation for my client and necessary protections moving forward. The judge nodded. And the defendant? Diane's attorney rose nervously. We've reviewed the proposed settlement, Your Honor. My client is prepared to accept the terms. This announcement sent murmurs through the courtroom. After months of defiance, Diane was surrendering, a development few had anticipated. Judge Wilson reviewed the settlement document carefully before addressing Diane directly. Ms. Mitchell, do you understand that by accepting these terms, you are acknowledging your actions constituted harassment and discrimination against the plaintiff? Diane's jaw tightened, but she nodded stiffly. Yes, Your Honor. And you accept? All terms without reservation. Another tight nod. Yes, Your Honor. The settlement terms were comprehensive. Diane would complete 200 hours of community service with disability advocacy organizations, attend mandatory education on invisible disabilities, pay damages covering my legal fees and vehicle repair, and most significantly, agree to a permanent restriction from any HOA or community leadership position in the county. Additionally, Judge Wilson noted, this agreement does not impact the separate federal investigation regarding impersonation of government officials or potential fraud charges, which will proceed independently. As the judge formally approved the settlement, I studied Diane's expression. There was no contrition, no acknowledgement of understanding, only the grim resignation of someone calculating that this concession was preferable to risking a trial with mounting evidence against her. Outside the courtroom, I finally learned what had prompted this sudden capitulation. Elizabeth pulled me aside as Diane hurried away with her attorney. The federal investigation uncovered something. Diane has been running a business called ADA Compliance Consultants for years, charging HOAs and small businesses for official certification they didn't need. When the feds executed a search warrant yesterday, they found extensive records of these activities, including payments from multiple communities. So her crusade against me wasn't just about parking, I asked, pieces falling into place. It was partly about maintaining her perception as an authority on disability compliance, Elizabeth confirmed. Your legitimate accommodation threatened that image. If residents realized she couldn't determine who was really disabled, her consulting business would be undermined. The revelation that financial motives had partly driven Diane's campaign added a cynical dimension to what I'd previously viewed as misguided principle. Her harassment hadn't just been about policing disability, it had been about protecting her fictional expertise and income stream. As we walked toward the courthouse exit, we passed a small conference room where Diane sat with federal agents, her public defender now joined by a criminal defense attorney. Our eyes met briefly through the glass, hers quickly darting away, unable to maintain contact. For the first time, I saw not the confident enforcer, but a woman facing the dismantling of both her community status and her fraudulent business. Back at Meadowbrook that evening, news of the settlement spread quickly. Rachel organized an impromptu gathering at the community gazebo, where residents expressed relief that the conflict had concluded. "The board is implementing new policies next month," Walter explained to the assembled neighbors. "Clear procedures for accommodation requests, privacy protections for medical information, and mandatory training for all committee members about disability rights." Tom, my supportive neighbor from the beginning, raised his glass of lemonade. "To learning from mistakes and becoming a better community." The sentiment resonated, though I noticed several of Diane's former allies were conspicuously absent. Healing. The community division would take time. Some residents had invested heavily in Diane's perspective and wouldn't easily acknowledge their role in enabling harassment. 3 days later, the final act in Diane's reckoning arrived without warning. A moving truck appeared outside her townhouse at dawn. By midday, most of her belongings had been loaded, and by evening her unit stood empty, except for a "for sale" sign hastily planted in the small front garden. She left without goodbyes or explanations, a quiet exit for someone who had created such tumult. Neighbors reported she had purchased a condominium in a different county, presumably to escape both the restraining order's restrictions and the community's changed perception of her. The federal investigation continued in her absence. Over subsequent weeks, representatives from the Department of Justice contacted other communities and businesses that had paid for Diane's official certification, building what appeared to be a substantial fraud case. As Meadowbrook adjusted to her absence, I noticed a subtle but significant change in daily interactions. Residents who used mobility aids or had visible disabilities reported feeling more comfortable in common areas. People became more willing to discuss health challenges openly without fear of surveillance or judgment. The educational forum we had organized evolved into a monthly support group for residents with various health conditions. Most meaningfully, 3 other homeowners with invisible disabilities who had been silently enduring their own versions of scrutiny began using their legally protected accommodations without shame or apology. The reckoning hadn't just been Diane's, it had been the community's collective awakening to invisible disability rights. What began as one woman's campaign against my parking space had culminated in a reckoning with broader issues of accessibility, privacy, and the fundamental right to accommodation without constant justification. As I parked in my designated space, one evening, now a routine action without anxiety or surveillance, I reflected on the costly path to this resolution. The legal battles, community division, and personal stress had been enormous, yet the outcome had created ripples of understanding that extended far beyond my individual situation. Sometimes reckonings aren't just about accountability for past actions, but about establishing clearer vision for moving forward. Meadowbrook's reckoning with disability discrimination had been painful but necessary, transforming not just policies, but perspectives in ways that would benefit residents long after the details of our conflict faded from community memory. 6. Months after Diane's departure, Meadowbrook Estates had transformed in ways both visible and invisible. The physical changes were immediately apparent. New ramps at the clubhouse entrance, improved lighting along walkways, additional handicap parking spaces distributed throughout the complex, and braille signage on common area facilities. Less visible but equally significant were the shifts in community attitude and governance. The HOA board, once passive and conflict avoidant, had embraced a proactive approach to accessibility and inclusion. Their monthly meetings now regularly included discussions of accommodation needs, with a dedicated committee focused on ensuring community resources were accessible to all residents. I had been invited to join this accessibility committee alongside Rachel and 2 other residents with various disabilities. Initially reluctant, my fight had been for personal peace, not community leadership, I eventually accepted, recognizing the unique perspective I could contribute. "We need your voice," Walter had insisted during his 3rd attempt to recruit me. "You experienced firsthand how our community failed to protect your rights. Help us ensure it never happens again." On a bright spring morning, I arrived early for our quarterly accessibility walkthrough, a new practice where committee members systematically evaluated the entire property from an accessibility perspective. Rachel met me at the clubhouse, clipboard in hand, ready to find all the things most people never notice, she asked with a smile. We spent 2 hours examining everything from path gradients to door pressure, pool access to mailbox heights. What had once been overlooked details now represented potential barriers for residents with diverse needs. Our notes would become action items for the maintenance team, systematically improving accessibility throughout Meadowbrook. As we concluded our assessment, I noticed a moving truck backing into a familiar space. Diane's former townhouse had finally sold after sitting vacant for months. A young couple emerged from a car parked nearby, the woman using forearm crutches to navigate the walkway. Rachel and I exchanged glances, both thinking the same thing. Without Diane's hostile oversight, Meadowbrook had become a community where someone with visible mobility needs felt comfortable purchasing a home. Should we introduce ourselves, Rachel suggested. We approached the couple with friendly waves, offering welcome and assistance. Jessica and Michael were moving from an apartment that had never properly accommodated Jessica's cerebral palsy. We visited several communities, Michael explained, as we helped carry lighter boxes. Meadowbrook stood out because of all the accessibility features and the clearly marked accommodation process on your HOA website. That's relatively new, I admitted. The community has been on quite a journey with accessibility awareness. During a break from moving, I gave them a tour of the amenities, pointing out recent improvements and the locations of all accessible parking. When I showed Jessica the dedicated space near her new home, she looked relieved. Our last building had one handicap space that was always taken by the manager's mother, who didn't have a permit, she explained. When I complained, they suggested I just walk a little further, on days I couldn't find close parking. I shared a knowing look with Rachel. You won't have that problem here anymore. Accessibility rights are taken seriously now. That evening, a small gathering formed at the gazebo, an impromptu welcome party for the new residents. Tom brought his famous homemade salsa, Walter handled the grill, and several other neighbors contributed dishes and drinks. As Jessica and Michael mingled, I observed how naturally residents interacted with Jessica's disability, offering assistance when appropriate, but never making it the center of conversation. It's remarkable how much has changed, Rachel commented, quietly as we watched the gathering. Remember when people would literally cross to the other side when they saw us coming, afraid they'd get pulled into the disability drama? I nodded, recalling the tense months when the community had fractured around Diane's campaign. From surveillance to celebration. Who would have thought? Later that week, the final report from the Department of Justice investigation arrived. Diane had ultimately pleaded guilty to multiple counts of fraud and impersonation of a federal officer, receiving probation, substantial fines, and mandatory disability rights education. The report included a comprehensive compliance review of Meadowbrook, acknowledging our significant improvements while identifying a few remaining areas for attention. We've been cited as a model for HOA accessibility transition, Walter announced proudly at the next community meeting. The Justice Department is using our policy updates as examples for other communities. The irony wasn't lost on anyone. Diane's campaign against accommodation had ultimately created one of the most accessible communities. Meadowbrook celebrated the completion of its accessibility upgrades with a community-wide event. The central parking lot was transformed into a festival space with food trucks, information booths from disability organizations, and activities designed to be accessible for all abilities. The highlight was the unveiling of a new community charter, prominently displayed in the clubhouse. Meadowbrook Estates, where accessibility is our foundation. Beneath this heading were principles developed by the Accessibility Committee, emphasizing equal access, dignity, and the understanding that disabilities, visible and invisible, are part of human diversity rather than problems to be questioned or policed. As residents mingled during the celebration, I overheard a conversation between Jessica and another neighbor that captured the community's evolution. I was nervous about moving here, Jessica admitted. Our realtor mentioned there had been some issues around disability accommodation in the past. That's putting it mildly, the neighbor replied. But honestly, that conflict was the best thing that could have happened to Meadowbrook. It forced us to examine assumptions many of us didn't even realize we held. Now, accommodation isn't something we reluctantly provide. It's part of our community identity. My parking space, the catalyst for so much conflict, had become just another unremarkable feature of daily life. I parked there when needed, used street parking on better days, and never had to justify my choices to anyone. The freedom to manage my disability without surveillance or judgment was precisely what I had fought for, not special treatment, just the dignity of privacy and accommodation. 1 year after Diane's departure, a small envelope arrived in my mailbox with an unfamiliar return address from another state. Inside was a brief note on plain paper. "I was wrong about you and others. The education program has been illuminating. I still have much to learn. DM." No apology, no request for forgiveness, but an acknowledgement of error, perhaps the most anyone could expect from someone whose identity had been so thoroughly constructed around being right. I shared the note with Elizabeth during our final legal follow-up meeting. "That's more reflection than most plaintiffs ever receive," she observed. "The educational component of these cases often feels like a formality, but occasionally it genuinely changes perspective." As I drove home from that meeting, I passed the community entrance where Diane had once parked daily to monitor my comings and goings. Now children played freely on the adjacent lawn, and residents chatted comfortably by the mail kiosks without, checking over their shoulders. The visitor parking area near my townhouse, once the battleground for Diane's territorial campaign, had been redesigned to include 2 accessible spaces with appropriate signage and access aisles. Jessica often used one when visiting for our weekly coffee meetups, without anyone questioning her right to be there. Parking my car in my designated space had become exactly what it should always have been, an unremarkable daily action rather than a political statement or act of defiance. This ordinary normalcy represented the true victory, not winning against an opponent, but creating a community where accommodation was neither questioned nor celebrated, just provided as a matter. Of course, as I entered my home, I passed the framed copy of our new community charter hanging in my entryway. The final principle, which I had contributed during our drafting sessions, seemed particularly fitting after receiving Diane's note. Accessibility is a journey of continuous learning and improvement, not a destination to be reached. Meadowbrook's journey hadn't ended with Diane's departure, or even with our physical improvements. True accessibility would require ongoing commitment, education, and willingness to adapt as needs evolved. But for the first time since moving in, I felt confident this community was genuinely committed to that journey, not just in policy documents, but in daily interactions and shared values. The accessible community we were building wouldn't be perfect, but its foundation was now solid, a commitment to learning from past mistakes and growing into a place where everyone could belong exactly as they were.